Yeah.
We'll start proceedings with the character. If you want to stand. Brianna, if you want to lead us off.
Oh, I took a photo. I'll see if it's any better because my eyesight's terrible.
On the board.
Okay, karake te matanga, mai te pai maunga, raro ki te tai, mai te ha awa tonga, raro ki te awa rake, tēnei te hāpore a whiai te taratari, whano haramai te toki, huie, tai ki.
Thank you. Good morning, everybody. It's Monday, the 26th of August, 2024. This is day one of hearing string 2 into the combined Wairarapa district plan hearings. Topics being covered over the next few days are the general residential zones, the centres and town centres and neighbourhood zones, the mixed use zone, the industrial zone, the open space and recreation zones, and the future urban zone. 2 weeks ago, we completed hearing string 1, dealing with strategic objectives and direction and whole of plan issues. Following that hearing, I issued minute number 3, which gave some directions to certain parties regarding the need to have some expert conferencing. And those matters particularly relate to renewable energy topic involving Indigenous in the offices, and also the topic of 3 waters, and in particular the concept of Te Mana o Te Wai could, or whether it needed to be incorporated into the district plan. And that was a topic for a number of submitters in Greater Wellington Regional Council. That minute number 3 is on the hearing webpage, and the timetables associated with those directions are set out clearly in that minute. It's possible that there'll be further minutes following completion of day 2 of these proceedings, hearing string 2. I think just for the record, we'll introduce the panel with a slightly smaller panel than last time. We had 9 people last time, now down to a comfortable number of 5. My name's David McMahon, I'm the independent chair, a planning practitioner based in Wellington.
Kia ora, Robin Cherry Campbell, Deputy Chair and Carlton District Councillor and Commissioner.
Kia ora, tēnā tātou katoa. Ko Kiriana Hai, and independent councillor and representing Kahununi, Ngāti Kahununi, ki Wairarapa.
Morning, Alistair Plymouth from South Wairarapa District Council.
Kia ora, Craig Bayer, South Wairarapa, not South Marsden District Council.
Wants to be South Wairarapa.
Early.
And we'll be back.
Thank
We'll
you
be
all.
together.
And we have a recording for those that are present from the officers in any no particular order.
Cool. My name is Erica Wheatley. I work at Boffa School. I'm the reporting officer for the residential topic.
Kia ora. My name is Maria Moore. I'm an urban designer with Boffa School, so I am here to address the urban design matters.
Thank you.
Kia ora, I'm Alice Falloon. I'm an intermediate resource planner with Marsden District Council.
I'm Becca Adams, planning officer at Carterton District Council and reporting officer on the open space and recreation zones.
Good morning, everybody. Solomon Wilson, planning and regulatory manager, Carterton District Council, and reporting officer for the industrial zone, and co-reporting officer in conjunction with Becca for the future urban zone.
Yes, down the back.
And she was me from Boffa School today for the camp officer thing.
Thank you.
And to be Wilson, a school planner at Castle. Yes.
Representing Canoe.
Yes.
Yeah. Thank you, Ms. Thompson. And of course, but last but not least, Ruth.
Ruth, hearings administrator.
Thank you, Ruth, and thanks again for your work in the lead up to these hearings. Appreciate it. Okay, are there any procedural matters arising before we hear from Erica Whitley? No? Okay, thank you. Erica, we're in your hands. You've got a summary statement that you're prepared. I'd want you to take us through that. I don't think there's any need to rush proceeding, plenty of time. Your topic contains a number of things that are replicated in a number of the other reports. So we'll probably spend a little bit of time on that for that reason.
Yeah, sure. As you say, some of the things I will cover here, it will be another topic, so I will first and foremost. Cool. Thank you, Mr. Chair. My name is Erica Wheatley. I'm a senior professional planner at Wairarapa, engaged by 3 Wairarapa councils to assist with the district plan review. I began working on the review early in the process in 2021, and I've worked on a range of topics throughout different stages of the review. I've led the residential topic from the beginning. I prepared the Section 42A report for the matters relating to the general residential topic, and my qualifications and experience are set out in that report. The general residential topic includes the general residential zone chapter, its precincts, related definitions, the parts of the subdivision chapter that relate to residential zones, and the residential design guide, as well as some relatively straightforward mapping amendments for the residential zones. A summary of the contents and functions of the general residential topic is contained in Appendix 1, if you wish to look at it.
I wonder whether we could go to that now, just as context. It might save a lot of unnecessary questions later on.
Sure. Just aware that this was a long thing, so I put it at the back in case, but we can certainly go through that.
That's on my copy. It's on Appendix 1, isn't it?
Yes, Appendix 1 is, sorry, the page numbers have fallen off.
Yes, that's a bugbear of mine. So
Yeah, it has them on the online version, I'm sorry.
That's page 30.
Cool.
Vision.
Cool. Alrighty. So as mentioned, the residential topic includes all those various things I just mentioned. It predominantly provides for residential activities with a mix of building types and other compatible activities, which are essential for Wairarapa residents to provide for their health, social and economic well-being. Residential character can change over time to meet changing residential needs, and more intensive forms of urban development need to be well designed to ensure that positive residential character outcomes are achieved. To support these outcomes, the General Residential Zone chapter contains 5 objectives. The first outlines the purpose of the General Residential Zone, which primarily consists of residential activities to cater for a variety of housing needs. The second sets out the character and amenity values of the zone, including the built form and living environments. The third limits non-residential activities in the zone to those that are compatible with and support the functioning of the zone. The fourth outlines the purpose, character, and amenity values of the low-density residential precinct, which protects residential character values in Greytown and Martinborough. And the fifth sets out the intended purpose, character, and amenity values of the medium-density residential precinct, which seeks to enable denser, well-designed residential development in Masterton and Featherston. Supporting these objectives, we have 8 policies in the General Residential Zone chapter. The first enables a range of residential activities. The second promotes variety, innovation, and good design outcomes for residential development. The third enables compatible non-residential activities in the zone. Fourth provides for activities and structures that support the character of the zone. The fifth maintains the character and amenity values of the low-density precinct. The sixth provides for activities and structures that support the planned residential character of the medium-density precinct. The next one avoids residential development where there's insufficient infrastructure capacity. And lastly, the final policy promotes rainwater collection and use, which supports the rainwater tank provisions.
I think we can probably take the table
Yes.
read the colour codings self-explanatory. And then there's paragraph 6 with a range of standards following book form.
Great.
And activities. Then you might want to tell us a little talk to item 7 about the residential design guide?
Yes, so the residential design guides, which Miriam is here to support with, along with the commercial design guide. It sits in Appendix 4 of the proposed plan. This provides guidance on how to achieve good quality urban design outcomes for multi-unit dwellings in response to the anticipated increase in multi-unit developments we are expecting to see, which are enabled under the plan. The residential design guide also provides guidance to undertake additions, alterations, or construction of new buildings within identified heritage precincts so that they fit within the overall context of those. The guide helps to implement the objectives and policies relating to quality urban design and recognises residential character and heritage values.
I have 2 generic questions, Ms. Wheatley, on the content that I want to put to you, and it may be that the panel will have some supplementary questions also. First is the issue of precincts.
Yes.
So we have a general residential zone.
Yes.
Within that zone, there are spatially identified precincts for low density residential and medium density residential. Can you tell us about where we find those precincts and what effectively they do to the general residential zone rules?
Certainly. Okay, so the main reason that these are precincts relates to how they affect the general residential zone rules. Effectively, these precincts only allow for an increased density. So
medium density?
Correct. Increased density in the medium density precinct and a lower density in the low density precinct.
And if you're talking about density, we're talking about presumably both subdivision site, minimum allotment sizes and number of units?
Number of units per site, yes, residential units. So, for example, in GRZ Rule 4, we have a residential zone, which is the standard that applies over most areas. We have 350 metres per residential unit of net site area and 1 residential unit per 400 square metres of net site area thereafter.
Yep.
Medium density allows 1 residential unit per 200 squares, and low density allows 1 residential unit per 400 squares per site, and then 1 residential unit per 500 squares thereafter.
And the minimum lot size is from 350 in the general?
350 in general, 200 in medium, and 400 in low density.
Okay. And what are the main locations where the medium density precinct are found?
So the medium density areas are primarily found in the residential areas just to the west of Marston Town Centre, and that are accessible to the main centre of the town. And the low density precincts cover the spatial extent of residential areas in Greytown and Martinborough.
Reference in the report to precincts 1, 2, and 3. Are they sub precincts, or how do they work? Is it the low density or the medium density, or is it something completely different?
It is something completely different. It gets a little confusing being called precincts all over the place, but unfortunately that's kind of the direction of the national planning standards. So precincts 1, 2, and 3, they relate to, sorry, it was just having a bit of a thing. The first one, precinct 3 relates to the Cashmere Oaks development that's north of Masterton. Precinct 2 relates to the Greytown development area, which has recently been approved resource consent for development. So that kind of implements those resource consent rules for those 2 developments. And precinct 1 relates to the Orchard Apartment Village, and again, it kind of gives effect to those conditions that were part of that resource consent.
So these are all precincts of the general residential zone, and they've got bespoke provisions relating to that particular development that they cover. Okay. Two further questions arising with the medium density zone. Is that the vehicle, sort of medium density precinct? Is that the vehicle for enabling multi-unit development?
Primarily, yes. You can go for multi-unit development in other zones, but it will tend to, if you want to go denser than is set out in GRZ Rule 4, then it increases different activity statuses depending on, that are generally more difficult at lower density. And
for the low density precinct, other than controlling density, is there a character amenity and heritage function to that precinct?
slightly tricky question. Best way to answer that I can say is bearing in mind the kind of distinction that the NPSUD distinguishes between heritage and character. The low density precinct straddles a tricky line between the two. For the most part, it protects residential character of those areas, of which the heritage values that are perceived by the community form part of that. However, as far as I know, they aren't, say, scheduled or to the same rigor as, say, the heritage chapter or heritage listed precincts.
So they're not heritage precincts?
No, they're character.
Final question relates to the residential design guide. Firstly, does that relate to all three precincts or just the low density?
So there's kind of two components of the residential design guide. There is the heritage component, which relates to if you want to undertake alterations, amendments, new buildings within identified heritage precincts. So that falls under the heritage chapter and its associated schedules. So where the residential areas overlap with that precinct, then that heritage design guide applies. The second part is the multi-unit residential design guide. So as you would expect, that's if you want to undertake a multi-unit development, which we generally expect to be in the medium density precinct, but could feasibly occur anywhere if a resource is limited. It provides some really good direction on how to achieve good design outcomes and design things well so that they work for people and the communities.
Yes. In terms of the trigger for the residential design guide being applied, obviously in a heritage precinct, that all development presumably is subject to some form of consent that would invoke an assessment against the design guide or the heritage component of the design guide. Is that correct?
They tend to be matters of discretion, yes.
So
there where we can, or referenced in objectives and policies.
Yes. And for multi-unit developments?
Again, tend to be listed as matters of discretion in the relevant rules. For example, Rule R4 for breach of density standards, but also referenced in the relevant policies.
So, for example, a multi-unit development that involved a site size greater than 200 and what was the standard for 1 per 200 on the
medium density? Yes.
Yeah.
Yep.
Wouldn't, where there was compliance with those rules, presumably would not invoke the design guide.
Wouldn't invoke it strictly, but at the same time, it's also there to provide some general good design guidance, because often those it's an extra cost for a developer to go through and get bespoke design guidance. So having that as an appendix, helps them to.
Yes, but that would be on a voluntary basis, but assuming there was no need for a resource consent.
Correct.
So 2 or more units is a multi-unit, really 2 or more.
Effectively, yes.
That was all from me, on that context. Thank you for that. That's been pretty useful.
He's a little bit out there. Just, I'm sure it's here. I can't find anywhere. When you say residential unit, and rule 4, we talk residential unit.
Yes, yep.
Is that a single dwelling?
Residential unit, it can be, say, a dwelling, like a separate standalone dwelling, or it could be, for example, an apartment where it's a self-contained unit.
Okay, so, yeah, so that's basically occupied by one family, one person.
Yeah. And
So how does that fit? How does that then fit with multi unit, so apartments so if you say, that we're talking no more than one residential unit per 200 square metres, what about if you're going up?
So that.
What's the definition of that? How does that fit? I can't find it. So I'm sure it's in there.
So on the face of it, potentially a very simple answer. If your site size is 400 square metres, make it easier maths wise, you can have two units on that site. If you want to go up and say have 2 on the bottom and 2 on the thing, that's 4 residential units per site. So it would breach that rule and require resource consent.
Okay, so so do we need? So is that specified in there that you would need to do you'd need a resource consent? Because I couldn't find it. I couldn't find the definitions there. It's a sort of, if I'm a developer and I want to, I've got a 400 metres square section, and I want to put in 4 units. How do I go about that within these rules? Is there a guy that's going to take me down a process?
Effectively, it's just those density standards that says, for example, medium density, 1 residential unit per 200 square metres. So it's just the base mathematical calculation that you'll have to do.
So that would automatically trigger, like it's quite clear, 1 residential unit per 200 square metres.
Yep.
So 2 would require,
And if you don't meet any of these, you go straight into a restricted discretionary. You don't. 1B. Oh, well, that's 1B, isn't it? The medium density. So you change that. That would now read 1A and B. Whereas non-compliance with C would become a fully discretionary under your revised recommendation. Previously a non-complying activity.
Correct.
Craig?
Let's go that way for a bit and then we might come back.
no, I'm not.
Yeah.
No, I'm fine, thank you.
Okay, we can probably continue. Craig, yes.
Going back then, and I may be very much the wrong end of the stick here.
That's okay.
The medium density residential precinct.
Yes.
If I wanted to build a unit of 100 square metres, that is still applicable here?
As in the unit size or the site size?
Unit size.
There's no limits on the size of a particular dwelling.
No more than 1 residential.
So a dwelling can be as big or small as you want it to be.
So what would the standard would be site coverage, presumably?
Yes.
The ratio of the floor area to.
Yeah. And things like setbacks and sundry.
Boundary setbacks and stuff like that, yeah.
Mostly boundary setbacks, yeah.
And they're generally covered in the standards, aren't they?
I'll like this for a discussion point.
The rules that, just one final question for me, the rules that trigger the assessment against the residential design guide, do they have any guidance on how those applications will be processed on whether they're not on a notified or non-notified basis?
Not within the design guides themselves. It will generally be left up to the discretion of the processing planner.
Yes.
And section 95.
Stand silent on that, is it?
Effectively, yes. I don't think there's any particular requirements or preclusions for notification.
Probably take you all the way back to your first page. That's been a useful. Thank you.
No worries.
So item 3,
Yes, all right. So in terms of the matters raised in submissions, a total of 32 original submissions and 10 further submissions were received on this topic. They were generally supportive. Where they did seek amendment, it was generally to support a specific outcome in the zone, for example, good urban design, or to provide for specific activities, for example, retirement villages, or to change the permitted levels of activities or standards, for example, changing the density or permitted building height. In terms of the pre-circulated evidence, I've read the respective evidence submitted in relation to this topic, which is Ms. Rosser for Enviro NZ, Ms. Hepplethwaite and Ms. Grinlinton Hancock for Kiwi Rail, along with the supporting legal submission from K.L. Gunnell at Russell McVeigh for Kiwi Rail, Ms. Zollner for Greater Wellington Regional Council, Mr. Talbot for New Zealand Transport Agency, Mr. McGinsey for Fire and Emergency New Zealand, Mr. Lewandowski for Somerset Group Holdings, and Ms. Levinson for Horticulture New Zealand. I've also read the evidence submitted by Mr. Barner Thompson on behalf of New Zealand Heavy Haulage Association. However, as this was submitted after we prepared these statements, it's not included in the text you've received today, this morning. However, the evidence doesn't raise any additional matters, and so I therefore remain of the view stated in the Section 42A report with regard to relocatable buildings. I also acknowledge that Mr. Talbot, yay, and Mr. Lewandowski on behalf of Somerset support the recommendations of the Section 42A report. And Ms. Levinson from Horticulture New Zealand no longer seeks an objective to manage reverse sensitivity issues on the rural-urban interface in the general residential chapter. And I respond to the remaining evidence. Changes recommended are included in Appendix 2. Alrighty, moving.
So could I just interrupt you there? Sorry, Ms. Levinson, is that because of the new definition of reverse sensitivities that we did in the last hearing?
No, my understanding is that in response, the reasoning I've given in my Section 42A response is sufficient to answer her query, rather than it being the definition.
Sorry for interrupting you.
No, no worries. Gives me a little breather. Alrighty, moving on to key issue 1, paragraph 9. Ms. Zollner for Greater Wellington seeks clauses 1, 3, and 4 of Objective 02 be amended in the bullet points set out under paragraph 9, which generally relates to opportunities for higher densities on well-located and suitable sites, deleting openness around and between buildings, deleting reference to a spacious living environment, and correct reference to shared open space and on-site outdoor space, and including reference to walking, cycling, and public transport. I generally agree with Ms. Zollner as set out in paragraphs 10 and 11, with the exception of adding reference to walking, cycling, public transport. Objective 02, in relation to that point, that clause reads, an urban environment that is visually attractive, safe, easy to navigate, and convenient to access. And I consider that adding the text through walking, cycling, public transport, it goes into specifying how that objective should be achieved, which is more the role of a policy rather than an objective.
just pause there, please. In response, in support of your position at 11, you've said that policies P2 and P6 really do the heavy lifting there. We don't need a new clause 4 or amendment to clause 4 of the objective.
Correct.
Have you considered whether policies C2 and P6, if there was scope, needed any tweaking at all?
I think I've mostly considered that through the 42A report and a little bit through these prior. So those policies have to refer to things like active and public transport already. Recommendation.
I definitely see that in relation to P2.
Mm.
It wasn't necessarily, oh yes, clause 5 of P6, I imagine, reliance on private vehicles is reduced.
Yes.
Okay.
Generally, the function of the medium density precinct, you know, it's important.
5.5. What even? I don't remember.
Yes, this is right. Thank you. Just- Thank you.
No worries. Okay, moving on to point 2. Again, Ms. Zollner for Greater Wellington seeks the word safe be added in reference to active and public transport modes, which I agree safety is an important consideration and should be added to the objective for O2. Next one, which is P4, which is paragraphs 13, 14, 15. Ms. Zollner for Greater Wellington seeks that policy P4 be amended in the bullet points set out under paragraph 13, which generally seeks to delete reference to development on single sites and again correctly refer to shared public outdoor space rather than open space and amenity, and also delete reference to within a generally spacious setting. I generally agree with Ms. Zollner's proposed amendments. And multi-unit development doesn't necessarily need to be on single sites. If there is a development that meets the objectives and policies that is across multiple sites, that's not necessarily an undesirable outcome. And I also agree that the shared public outdoor space wording amendment clarifies, is more clear than the terminology currently used. And I also recommend deleting the wording within a generally spacious setting from clause 2, as outdoor space is already covered in clauses 1, 4, and 5 of the same policy.
Thank you.
All right, moving on to key issue 3, which is low density residential precinct. Ms. Zollner again seeks that the low density precinct be removed from Martinborough and Greytown, or alternatively, if the precinct is retained, that it be reduced to only cover the areas where identified character values exist. I set out some statutory considerations in paragraph 17, if you wish to look at that.
I do. I have a question that you may want to reflect on and come back to it.
Sure.
Paragraph 17, you say, you know, Ms. Zollner's point where there is conflicting direction between different higher order documents, that a district plan must give effect to the regional policy statement. I'd be interested in what the legal authority for that position is.
I will double check that and come back to you. So the authority for that position.
Yeah, I'll put that same question to Ms. Zollner also.
Okay. Cool.
You're quoting her there.
Cool. I will make sure to cover that and come back to you.
What's the point that you're making here that if we can't resolve tension between two higher order documents that we have to give effect to, then we go down a rung to the regional policy statement? Is that what you're saying?
I think it's more just acknowledging that there is direction within the regional policy statement that relates to the points Ms. Zollner has raised in terms of allowing for intensification in compact urban form, but it also seeks to protect it seeks to protect heritage values. So I'm more saying that there's a dual objective.
What's the two higher order documents that are in tension here?
Once I think the tension that she refers to is that the regional policy statement seeks the compact urban form. And she sees there's a tension between that and the South Wairarapa spatial plan, which seeks to protect the residential character values in Greytown and Marshall.
Okay. So presumably she's saying that if it's a contest between the spatial plan and the RPS, she believes that the spatial plan should, the RPS should prevail.
Correct. Understanding.
We'll test that with you.
Sure.
Thank you.
Thank you. Moving on to paragraph 18. I don't consider.
Oh, 18, yes, sorry.
Yes. I don't consider it as appropriate to delete the low density precinct.
Sorry, can I ask a question? Do you know whether the South Wairarapa District Council, the Regional Council was involved at all in the spatial planning process in South Wairarapa?
I'm not aware. I wasn't involved myself. As Russell O'Leary, who's the planning manager, might be able to answer those questions more.
We get an answer to that question because they had public hearings, obviously, and it was all submitted. So if they missed the opportunity, well.
Cool.
Thank you.
Wellington involved in South Wairarapa special plan process.
Were you meaning is their involvement? Did they submit? Did they submit on it?
Did they have any involvement in it? What's that?
Cool.
Did they go to the hearings?
I'll certainly find that out for you.
Thank you.
Ready. I don't consider it as appropriate to delete the low density precinct from Marshall and Greytown due to the existing heritage character values identified through the South Wairarapa spatial plan process. In the absence of more recent or detailed assessment to refine the extent of the heritage character values in these towns, South Wairarapa spatial plan is the most recent evidence on this matter. In this instance, I consider a precautionary approach to protect these values as appropriate, as loss of heritage character values cannot be reversed. I do not recommend deleting or reducing the low density precinct applying to Martinborough and Greytown without taking additional assessment to refine its extent.
Okay. For that reason that I asked about the role of the low density precinct and what extent it was reflecting heritage values, he confirmed it's not a heritage precinct per se.
Yes.
Are there any heritage precincts in South Wairarapa?
From memory, heritage isn't my topic.
Yes, there is.
There is. Thank you.
Hence all the submissions from Greytown Heritage.
Yes, I'm talking about heritage precincts.
Yes, there is. Yeah.
Yeah, there's some.
Change the terminology to.
Yes.
It was heritage. So it's now reworded to heritage precinct.
Yes.
Is there any overlap between the heritage precincts and the low density precinct?
It's primarily focused around the centres of town. There is some limited overlap. I think there's spatially overlap with residential zones. I think primarily in Greytown from memory. I think there's very limited overlap in Martinborough.
Sorry, I might have phrased that poorly. Is there any overlap between the low density precincts and the heritage precinct?
Yes, there is.
Could you show that spatially?
Yeah.
And your right of reply?
Spatial overlap, low density and heritage precincts.
And it's the name Greytown, isn't it?
Yes.
Martinborough and Greytown, sorry. For both of those.
Correct.
So under 18, your recommendation is to maintain the spatial extent of the low density residential precinct in Martinborough and.
Yes, correct.
Yes. Thank you.
Thank you. On to key issue 4. Ms. Zollner for Greater Wellington seeks that residential areas within a walkable catchment, which she has defined as 800 metres or a 10-minute walk, of the Carterton Town Centre and train station be included in the medium density precinct. She also seeks that additional areas of Masterton are assessed for suitability for medium density development and are also subsequently included in the medium density precinct. Additional areas of medium density around Marston were not included in the proposed district plan, largely due to servicing issues across the town, which included a lack of capacity, instances of infiltration of stormwater into sewer systems and low water pressure in some areas. I understand investigations are currently underway to assess those servicing constraints around Marston, which will be used to inform a spatial plan, which I understand will be available sometime next year. I do not recommend any additional areas of Masterton being included in the medium density precinct in advance of this work being completed. Similarly, no spatial planning exercise has been undertaken to inform potentially appropriate areas for medium density in Carterton or identify any constraints. I therefore do not recommend the medium density precinct be applied to Carterton in advance of such work being done.
So essentially, you're saying this is for future investigation and future first schedule process?
Correct.
How does that? The panel was aware of some urban growth studies that have been undertaken in both Masterton and Carterton in the last 3 to 4 years. Why are they not suitable for identifying high density precincts in those locations?
So my understanding in Solitaire is Carterton, feel free to jump in. My understanding is that what we've put forward as part of the proposed district plan is already a significant increase from the current densities in Carterton. And so that's what those documents sought to look at. So anything on top of that would be additional, is that?
Yes, when the, if I may, Mr. Chair, when the Carterton growth strategy, the Eastern Growth Area Strategy, was first developed, we hadn't ascertained what the minimum lot sizes would be in the residential zone in Carterton and whether we were going to retain the larger land blocks within what is the Carterton South Structure Plan area, which is why that was identified. Moving forward through the plan process, it was determined that the best outcome for intensification within the residential zone was to remove those overlays and reduce that minimum lot size down, where as opposed to a 500 square metre average, we're now down to a 400 average over 3 or more lots with a
general res
minimum, and everything is general residential within the urban area.
Yes. Okay.
My same question previously for Greater Wellington involvement in that. Did they submit on that proposal? There were hearings on that, if I recall rightly, in the paper. Was that right? The hearings on your
I would need
strategy.
I would need to go back and have a look at who submitted on it. I don't believe GW provided feedback on that Eastern Growth.
But it was a public
consultation
process and hearings and so on.
Yeah, they included it in the FDS.
Yep.
Thank you.
So that's the situation for Carterton. What's the situation with Marston? I'm aware that there was reference to the Marston Urban Growth Study. Previous proceedings.
My understanding is, again, those have been incorporated into the proposed district plan as it currently stands today. And again, identifying those servicing constraints more specifically and identifying where even more dense development could occur, then that requires, I don't think the servicing constraints have been mapped. Unfortunately, Christine's not here to answer more specifically.
Online.
Well,
sorry, Christine is online actually. She wants to provide some more.
Good morning, Ms. Chong. Can you hear us?
Yes, Chairman, Mr. Chairman.
Sure.
Can I just come back to the question, please?
Yes. The question was, to what extent do the provisions in the Masterton General Residential Zone reflect the findings of the Masterton Urban Growth Study?
It did reflect quite a lot in that, but that document is actually quite an old document, done back in 2019, and then it was reviewed in 2021. So it did provide some information, but as Erica has mentioned, the infrastructure component of it has to be mapped into that to see whether there's capacity in the system now, and that's where we are going into the new special plan that Erica mentioned, which will be done next year.
For Masterton?
Yes, that is correct.
And does that have commitment from the Masterton District Council and a time frame and budget?
It is it has a budget, and it is proposed to be once we've gone through that, to be endorsed by the council.
Yes, so is that a 2025-26 line item, or is it got the years wrong there?
Definitely a 2025 timeframe.
Yes, thank you. Okay. Ms. Wheatley, some of these issues will also come up in relation to the future urban zone too. Thank you.
Moving on to key issue 5. Ms. Zollner for Greater Wellington seeks that Rule R4 be amended to make non-compliance with density limits a restricted discretionary activity. She also in the general residential zone and outside of the precincts. She also seeks that Rule R4, which is the low density precinct, be amended to make non-compliance with density limits a discretionary activity rather than a non-complying activity. I note Ms. Zollner's points that a discretionary activity status for residential activities exceeding density standards in the general residential zone is more restricted than the operative district plan. A general principle of plan making is to use the lowest activity status necessary to achieve the desired outcome. I consider that a restricted discretionary activity status would allow for all relevant matters to be considered as part of the resource consent process for GRZ Rule 4, which would allow councils to decline consent if the activity were inappropriate. I therefore agree and recommend that non-compliance with density standards in the general residential zone become a restricted discretionary activity. The matters of discretion would be the same as those for breach of the density standards in the medium density precinct, which is set out in points A to I underneath paragraph 3.
And we can take those as read. In fact, probably take up to paragraph 26.
Sure. For residential activities exceeding minimum density standards in the low density precinct, it's not considered that the gateway test, which applies to non-complying activities under the RMA, it's not considered that this provides any additional usefulness to council when considering a resource consent application of this kind. Accordingly, I consider a discretionary activity status would still allow councils to consider all potentially relevant considerations of breaching density standards in the low density precinct at the resource consent stage. I therefore recommend non-compliance become a discretionary activity in the low density precinct. On to GRZ Rule 10, minor residential units. Ms. Zollner seeks that Rule R10 be amended to make minor residential units that don't comply with the zone standards a restricted discretionary activity. She considers a discretionary activity status, as it currently is too restrictive, and restricted discretionary allows effects to be managed and does not overly restrict minded residential units and the potential to contribute to housing variety, affordability, and choice. I generally agree with her points. However, I've reviewed Greater Wellington's submission and further submission on the proposed district plan, and Greater Wellington did not submit on Rule R10, and so I consider these requested amendments are out of scope. However, I hope that my recommendations to amend standard S4, as we'll discuss later, goes some way to alleviating her concern.
Do you want to deal with that now or later?
Maybe later. It might throw me off slightly.
It's fine. I've just got a placeholder here.
Sure. On to key issue 6. We have Mr. McGimpsey for Fire and Emergency New Zealand, which if I say FEMS by accident, that's what I mean. He seeks that emergency service facilities be a permitted activity in the general residential zone. If this relief is not granted, he alternatively seeks a restricted discretionary activity status. Really sought this for all of these zones.
Yes, there's been a common theme there and a common way of dealing with it. That's noted.
Cool. I remain of the view that it's not appropriate to allow emergency service facilities as a permitted activity in a residential zone due to the potential adverse effects that would be generated between these facilities and neighbouring residential sites. In terms of making them a restricted discretionary activity, however, he had suggested some matters of discretion that are quite broad. Sorry, pardon me. They cover all potentially relevant effects of the emergency service facilities, but they are so broad as to not, in effect, be much different to that of a fully discretionary consent. However, as discussed earlier, general principle of plan making is to use the lowest activity status possible to still manage effects. As the matters of discretion can be defined, I recommend that they become a restricted discretionary activity in the general residential zone. I agree with the general content of the matters of discretion recommended by Mr. McGimpsey, but I have recommended some amendments to align with the wording and structure of similar rules in the zone and throughout the plan, which is set out in the following points.
Yes. A couple of things here. Do you have any discussion with Mr. McGimpsey on the matters of discretion?
Not as yet.
Okay. He and Mr. Allen are presenting tomorrow afternoon. So, how did you specifically derive those matters of discretion A to F?
Cool. So I don't have Mr. McGimpsey's submission right in front of me. However, I generally looked at the matters he had raised, which, for example, operational and functional need, which speaks to A, and intensity and scale of the activity, including the amenity effects, generally related to C, and also where there were other relevant matters of discretion that fell under similar rules, I have added those in, which example are infrastructure requirements and effects of non-compliance with.
The matter A. Hasn't that already been decided through the enabling provision of a restricted discretionary activity status in the zone?
To an extent, though because it's not necessarily, because the objectives and policies don't come into consideration as much as they would for a discretionary activity, I considered it appropriate to reflect that in the rule and not just rely on the policies where there is operational and functional.
What would you expect that FENS would need to demonstrate at the time of an RDA application to show operational or functional need?
That might be more of a question for Mr. McGimpsey, especially because he's the one who recommended that matter. But I expect something like a lack, something demonstrating a need for the service in that area and that the current services are insufficient to meet the needs for safety. I don't know what.
Are there any I think I know the answer, but are there any zones where emergency service facilities would be a permitted activity?
Not off the top of my head.
I thought.
Touched in the 42A report.
I think even in the general industrial zone, they are posed as a restricted discretionary. Okay, we'll take that up with Mr. McGimpsey tomorrow afternoon at 2:30.
Okay.
Issue 7.
Yes, issue 7. Ms. Rosser for Enviro NZ continues to seek a new standard be included in the general residential zone to require minimum storage and curbside areas for waste bins. If this is not accepted, she alternatively seeks the design guide be amended to require these areas. She also requests a consequential amendment be made to policy P6 to include reference to providing effective residential waste management, including curbside and/or on-site capacity for residential waste management. However, Enviro New Zealand did not submit on policy P6. I consider that component to be out of scope. Would you like me to go through paragraphs 34 to 37? It goes into quite a bit of detail about
Well, I do have some questions on the blue text and the standard.
second to last page.
Is it? S13?
Yes.
Yes, the question is, how have you derived that?
So that is, I believe, from the recommended text from Ms. Rosser.
Yes.
Partially from looking at the Auckland Plan Change 78 wording. And in particular, because if I remember correctly, the wording from Ms. Rosser stated that it must be accessible without stairs or a slope gradient, but then didn't define what that was. In terms of the slope gradient specifically, I looked at the NZTA accessibility standards, and so that's where that slope gradient has come.
Did you discuss any of those metrics with the council's development engineers?
No, unfortunately, they weren't available at the time of writing these for comment.
And one of the questions I've got is the ease of implementation of the rules. Obviously, the source, we've explained that. We may give you some direction on that following our hear from Ms. Rosser on that. If those standards, if S13 is not met, presumably it's an RDA, is it?
Yes, generally.
Where's S13 reference rules? Is that
I haven't done consequential amendments to bring that through the different rules, unfortunately. Now you mention it. But it would generally apply to where there is a minor, where there's a residential unit or a minor residential unit.
but how, yeah, if you could keep a note of the need to do that.
It's reference, yeah.
Let's come back to the scope issue.
Sure.
Seems that you were, absence of scope, you were reasonably convinced on the need for that policy change.
Yes. Certainly the evidence that Ms. Rosser provided and the evidence, especially throughout the Section 32 report for Plan Change 78, definitely substantiated that this is a problem that occurs and is in Auckland for multi-unit developments. And since we're anticipating more of those here, good preemptive.
Yeah. I guess what the panel's saying is that we understand the issue. The standard is quite a prescriptive approach. given that multi-units would be triggered for effectively 2 or more.
Yeah.
Rather than trying to prescribe a solution, is it something that could be a matter of discretion?
Yes, so that was my original stance in the 42A report. It's also referenced in the design guides as being a matter of consideration, matter of discretion, sorry. And it was referenced in matters of discretion for these rules. However, Ms. Rosser considered that leaving it up to the discretion of the processing planner, who doesn't have a particular expertise on how much space is required, has often led to suboptimal outcomes.
So does the design guide provide any assistance in that sense?
The design guide references actually only the storage of the accommodation of the bins, but not actually the waste collection, which I believe is the problem in the plan standards.
The design guide sits in the district plan or outside the district plan?
In the district.
Inside. Okay, well, there's some options there.
There are.
What we've got to, as a panel, we have to consider what's the most appropriate. We're down to a prescriptive versus an evaluative.
Yes, exactly.
Either way, notwithstanding that lack of guidance, if the panel ran with either of the prescriptive or the evaluative, would it be useful, do you think, to have some policy rationale for that?
Actually, before I considered out of scope, I did think that that could be a good option, yes.
Yeah. Could the policy change that you say it's out of scope, so that be considered as a consequential implement if there's effect to the rules?
Yes, certainly you could use that interpretation.
Well, again, we'll ask you to report back on that once you've heard from Ms. Rosser.
Sure.
All right.
6 consequential.
Could I just ask, on your, part 3, curbside collections used for hold waste, the last part in your blue. I can see that actually working when, if you're building on a site and the road exists. How do you then create a space where there is no space? Or because of course everything's now mechanical, so the machine drives along, picks it up. That seems to be something that council has to do.
Yes.
Rather than a developer who's developing maybe 10 metres back.
That was my initial thought too, is if it's on the curb, then how does a developer do that when it's not on the site? But I think from reading Ms. Ross's evidence again, I think she means within the site, at the site boundary, so that it's not all over the curb.
Okay, that's not what that says though.
Cool. Yeah, curbside space. So yeah, that wording could be clearer.
I think there's a question there from Ms. Rosser tomorrow. Thank you.
As I say, you need to have access for the actual contractors. Yes.
Because they literally sit on the side of the road. I'm assuming in most places that it's almost a grass verge, really, isn't it? You've got a footpath inside to can our town. And that's beyond the ability of the developer to do anything about it.
Yes, certainly. If that's what she intended, then yes, I would agree.
Okay. It takes a 4.8, but please. Sorry, paragraph 40.
Paragraph 40, yes. All right. This one is an amendment to include a setback for buildings from the rail corridor. Again, across zones. So Ms. Hebblethwaite for Kiwi Rail seeks that standard GRZ S3 be amended to include a 5 metre building setback from the rail corridor. I note she has provided an assessment showing that a rail corridor setback is the most appropriate mechanism to ensure safety of the rail corridor and the adjoining residents when compared to other options, which she has considered widening the rail corridor designation, fencing the rail corridor, managing access into the corridor via access requests. From the evidence she's provided, the risk to the safety of the rail corridor and adjoining residents appears to be related to the height of the buildings adjacent to the corridor. On this basis, I consider a height in relation to boundary plane will be a slightly more refined mechanism to manage this issue compared to a blanket 5 metre setback. which effectively nullifies the property owner of the ability to use that land. I go into a little bit of detail in paragraph 42 about the specifics of the general residential zone height in relation to boundary standard and the setback standard. In effect, I consider that the standards in the general residential zone, being the height in relation to boundary plane, effectively already requires enough space between the rail corridor and the building to allow for scaffolding and potential dropped objects, as demonstrated by Ms. Hepplethwaite in her evidence and the diagrams provided. I acknowledge there's a little bit of residual risk. The setbacks required by the height in relation to boundary planes don't fully account for potentially dropped objects. There's a little bit where it could go outside. However, there are other measures available to mitigate this risk, such as tool attachment points or debris nets to catch falling objects, to manage that residual a little bit where it might fall outside. Based on the above matters, I consider the existing height in relation to boundary standards sufficiently manages the issue raised by Kiwi Rail, and no additional setback standard is required in the general residential zone, but this varies across zones.
Panel noticed that recommendation is a little bit at odds with the recommendations to accept the 5 metre setback in some of the other zones, town centre zone, mixed use, GIZ, and I think 4 metres in the open space.
Natural,
open space. All of those officers cross-reference back to your report and say that they considered height in relation to boundary as a possibility, but came to the conclusion that it wouldn't work. Not sure there's a question there other than acknowledging that there's a different position.
Yes, and if I might provide a little bit of explanatory. In the industrial zone and commercial zones, those buildings are expected to be a lot higher than a conventional house, whether that's 1 or 2 story buildings. So the higher a building is, the more it's going to need to be pushed back by height in relation to boundary plane. So if there's going to be bigger buildings, it's going to result in a way bigger setback than 5 metres. So 5 metres for those was going to be smaller than a height in relation to boundary plane.
Okay, understood. Okay, I think we'll carry on to 10:30 and then we'll take a break. For everything by then.
Fingers crossed. Ready. On to standard S3. Ms. Zollner sought, Alpha Greater Wellington sought that the matters of discretion in 2 of standard S3 relating to streetscape and residential character be deleted, and that the term sense of enclosure be deleted from matters of discretion number 3. For deleting streetscape and residential character, non-compliance with front setbacks can have effects on streetscape and residential character, and therefore I consider that this should still be included as a matter of discretion. I do not agree that this is subjective and difficult to assess. And for matter of discretion number 3, I agree that sense of enclosure is not necessarily a bad outcome when it comes to denser developments. However, that's the kind of direction I'd expect to see at maybe a policy level rather than a standard. And non-compliance with side or rear setbacks can definitely affect a neighbour's sense of enclosure to an unreasonable degree in the context of a particular residential environment. So I consider this should also remain a matter of discretion to allow council to manage potential adverse effects. Standard S4, Ms. Zollner for Greater Wellington seeks that standard S4 be reinstated to exempt minor residential units from setback requirements. This touches back on Rule R10 for minor residential units, and I hope that this is the relief that might give her a bit of satisfaction here. Moving on, she notes that minor residential units not meeting a setback standard would become a non-complying activity under R10, which seems overly restrictive. I still consider that habitable such as minor residential units or sleep outs have the potential to have privacy effects when they are located close to the property boundary, and the most appropriate method of managing those effects is via a setback. However, I do agree with Ms. Zollner that a non-compliant activity status is relatively onerous, as non-compliance with zone standards usually defaults to a restricted discretionary activity. As a consequential amendment to deleting GRZ S4 as recommended in my 42A report, I recommend making non-compliance with setbacks a restricted discretionary activity for minor residential units in R10.
How are we, how do you see us implementing that, given the changes to the building with the granny flat legislation that's coming through and so on? Councils won't know about this, so.
Yes. Yeah, that's absolutely difficult because at this stage it was just a discussion document. So it's indicated a couple of potential options. And a lot of those options, some are more restrictive than what we've proposed in the proposed district plan, and some are less restrictive. So what we've done here, the approach we've got here is slightly different, but in advance of actual legislation being put forward, it'll be relatively hard to anticipate that. So the answer is not much of an answer, I'm afraid.
I'm sure we've talked about this before.
Yeah.
That legislation is likely to be passed before we make this operational. What happens then?
We'll deal with that at that time.
Okay.
Yeah.
Because we can't make decisions
can't.
on something that's not legislation as yet.
Yeah.
That could still.
Yeah. And the standards that they've indicated in the discussion document might, be more restrictive, less restrictive. We don't have a.
And we'll be having an integration wrap-up hearing probably in post-May next year. So if there's any legislative changes, not just in relation to granny flats, but any other matters that cause us to, and officers to reconsider the recommendations, that'll be the forum for that.
Thank you.
Can you just take us back to how that resolves that earlier issue then?
Cool. So let me just quickly flick back. So Ms. Zollner's issue with Rule R10 for minor residential units was that where they don't comply with zone standards, they should be restricted discretionary, as she considers the discretionary activity status is too restrictive.
Yes.
So although this is only one standard, the fact that she has singled setback standards out as being a potential issue where minor residential units don't comply,
yes,
I have made that a restriction discretionary activity.
Okay. So where do we take us through to your colour coding? Where do we find that change?
So that is in Appendix 2.
Yes.
It is under art, and I've added a new
yes
2 underneath that, and also amended number 4 non-complying to refer to the other standard.
Yeah, Councillor Plym has asked the question, how do these setbacks, particularly in terms of rear boundaries, relate to the setbacks in relation to the rail corridors where there's been a 5 metre in some of the other zones?
So any minor residential unit would still need to comply with the zone setbacks. And where these are breached, that's when a consent is required, and then we'd consider things like, is there a rail corridor there that needs a bigger setback? So it would be subject to the same standards as a regular residential dwelling.
Right.
Right, nearly there.
S9.
S9. Mr. McGinty for Fire and Emergency New Zealand seeks that standard S9 be amended to require all buildings and activities to be provided with a water supply in accordance with the Fire Service Water Supplies Code of Practice. States that standard is, sorry, he states the standard is sought in scenarios where a connection to a reticulated water network is not available, or where a higher level of service is required. In the first instance, lots in the residential zone need to be provided with a reticulated water supply connection. That's both in the zone chapter and the subdivision chapter. However, in the second instance where a higher level of service is required, for example, higher water pressure, the Wairarapa councils are aware there are some areas in the network where this can be an issue. While work is currently ongoing to understand the extent of these issues and what is needed, more detailed information is not currently available. Given the high potential consequences of a fire, I recommend taking a precautionary approach at this stage to require water supply be provided in accordance with these code of practice water supply standard. This will enable council to consider whether there is adequate firefighting water supply for new developments in the residential zone, or whether upgrades or on-site solutions might be required.
My question on this is the heading that we have, deleted drinking water supply. Is that, at the moment, I can't think of any council that does provide non-drinking quality circulated water. Is that, we're not in the game of putting water pipes out that aren't treated.
Yes, no, absolutely.
So my question then arises, if we delete drinking water supply, does that open us up to the potential, these standards might say, oh, you've got to actually have pipes there where if you don't have drinking water supply, you've got to put other pipes in. Is it that law of unintended consequences, perhaps?
Not as I understand, because that would be, that is council's role to provide potable drinking water. So that is on them to provide, and my understanding is that there's other legislations governing that. This is simply saying the intention of deleting drinking water supply is acknowledging that there's other uses for potable water, not just drinking, it's also for plumbing and that kind of stuff like that. So that was the only intention. I can consider if there's unintentional consequences, but at this stage I can't think of any, but I can consider it further.
That be alleviated your question, Mr. Plummer, regarding on that point 2 on your appendix 2, where a connection with council's reticulated water supply system is not on site must be supplied. That could possibly mitigate council's requirement then, possibly.
Was that a question too?
So I'm sorry, I was kind of just.
Have a think about it and come back.
Yeah, certainly.
Like,
This may be a question for Mr. McGimpsey, but you have to require all buildings and activities to be provided. What's your understanding of the word activities?
So activities are, for example, what's listed in the zone rules, whether, the residential activity, an emergency service facility, basically. I'm not
Very broad.
Yes, it's more a term that is used in this kind of context, like I'm not quite sure how to explain this well. That's the term we use when we say, what do we want to do on a site? It's an activity. It's like a land use or a subdivision is an activity. So it's kind of RMA speak, for lack of a better explanation.
We're nearly there. Again, any discussion on the proposed clause 2 with the development council?
Again, they weren't available to comment on.
So again, it's quite prescriptive.
Yes.
What's affected the question if you don't comply with the standard?
Yes.
Is the standard capable of a fair understanding of what is provided and accessible in accordance with the standard?
My understanding is yes. Solitaire, I think, if you don't mind me relying on you, I think you did a little bit more digging into exactly what the standard requires.
There is 7 fire water classification standards.
Yes.
And each of the councils will adopt what they require. Like, I can only speak on behalf of Carterton.
Yes.
We have a minimum of SW2, and the New Zealand Fire Service Code of Practice If you go and look at the documents there, it's how many litres per minute, how many litres per second with the pressure. So I don't, as I said, I don't know what the other two towns do have, but we're under FW2. And you'll note, I do touch on it later in my industrial zone report, that FW3 is the minimum fire water classification standard for non-residential buildings. And you may or may not have read that summary statement already. I don't know if that was pre-circulated, but Carterton District Council has done a study in the Wainawa industrial area in terms of fighting capacity within the network up there. But I probably will address that a little bit later. It's quite hard to understand the standards, and maybe that might be how do you interpret the standards might be a more suitable question for FENS being the experts in that area.
I think you're right. Thank you for that. Now, does that conclude? Oh, there's a miscellaneous item, I think.
Yeah, there's a miscellaneous item and then a little bit of a wrap up at the end, if that's okay. So key issue 8, relatively straightforward. Ms. Zollner seeks that the introductory text be amended to refer to Featherston and Carterton having a medium density precinct applying to it. As I've only recommended Featherston have the medium density precinct, I only recommend Featherston be included in the introduction. In section 5, I've set out the changes that I've recommended in the section 40A report and the changes I've recommended in the statement. And on to paragraph 58 with regard to correct submissions. I note that there was a submission point from Greater Wellington and a further submission points from Lana Wallace and Timothy Wallace that were included in the future urban zone submission table, but were not addressed in the report. Greater Wellington opposed the additional residential zoning of the land near South Road because it is on highly productive land. This, as an explanation, this area was rezoned from rural to general residential because it reflects the existing residential development pattern already there. The reason it partially covers land that looks to be rural is because the zoning pattern we've elected avoids split zoning a site, so having half the site that contains a house being residential and the other half being rural. It's just allocated the entire site to be residential. Accordingly, I recommend rejecting this submission point.
So was paragraphs 58 and 59 dealing with a gap?
That was just a missubmission, yes.
And is it a future urban zone matter or a residential zone matter?
It was incorrectly allocated to the future urban zone, so I've addressed it here in my statement.
Okay. Are we hearing from Mr. and Mrs. Wallace?
Not that I understand. I don't think so.
And Greater Wellington won't, Ms. Zollner's evidence won't have, did she point out that it had been missed?
Yes, she pointed out in her evidence that it had been missed, yes. Cool.
Okay, I'll just check with the panel. Is there any remaining questions?
No, thanks. We're not still discussions. No.
Thank you, Ms. Wheatley. I know we spent a lot more time on that, but I think it's worthwhile, particularly in relation to those common matters that will pop up in other reports. Again, matters the building setback and the activity status for emergency service facilities. So I think we'll take a 15 minutes. One peak and back at 10:45 for Ms. Filone.
Thank you.